So on slide 2, I've just got for you a quick outline of where we're going today and what we're going to cover. Broadly 7 headings that we're going to consider. I'm going to look at constructive trust to start with and review the recent developments in the case law that we've had since the landmark cases in the House of Lords and Supreme Court in Stack and Dowden and in Jones and Kernot. And then we'll do a similar process in relation to proprietary estoppel, looking at some of the latest case law guidance and examples of how the courts are dealing with these sorts of claims. Then we'll look at whether the rules make a distinction between dealing with a home and an investment property. We'll then briefly look at bank accounts and other assets of cohabitees and how the law works in relation to them. Then equitable accounting, how does it work now? And then, having dealt with the substantive law, we'll spend 20 minutes or so just dealing with procedural updates and looking at the key changes and developments in the civil procedure rules and in cost budgeting, which you need to know about if you're going to be dealing with these sorts of cases in the litigation context. And then finally, we'll just quickly deal with Brexit and can think about how that affects cohabitation claims. And the final topic, just the last few minutes, the Brexit effect. So pre-Brexit, the situation with jurisdiction was that property which was located out of the jurisdiction of England and Wales was governed, or at least disputes in relation to that property was governed by Brussels I. And the 2 relevant articles were Articles 5 and 16. The effect of which was that a claim in rem, claim against the property or in relation to the property itself, had to be brought in the courts of the country where the property is situate. However, an in personam claim can be brought in the country where the defendant is resident, sometimes in unusual circumstances where the agreement itself between the parties was made. Now, in Webb and then later Prasich and Prasich in the English Court of Appeal, Webb and Webb being a European court decision, the court held that equitable rights, so in other words, beneficial ownership rights to a property, were rights in personam, notwithstanding the fact that they were related to a piece of real estate. They were not rights in rem. And that meant that arguments about beneficial ownership of a property in France or Germany or in any other country in the world could be brought in the Court of England if the parties were resident, or at least if the defendant was resident in England. However, by contrast, a claim for an order for sale, rather than a declaration of beneficial interest, which is in personam, an order for sale is a right in rem. And in Coma and Magiera, that was made clear was a right of in rem, and therefore an order for sale can only be obtained in the courts of the country where the land is situate.